Hello, hi, I'm William Gamble, and I'm here to speak to you about U.S. state and privacy laws. In addition to all my certifications in cybersecurity, I'm also a lawyer and I've been so for many, many years. So we'll take a quick look at some of the privacy laws in for a very, very short period of time. Hopefully you can all hear me, and as we can go through the slides, please save any questions you have for the end. Anyway, to start off, this is about IT governance. We have 20 years experience, and I've been working here for about 5. We have tons of clients across international areas, and we do all sorts of different things. In addition to training, I also write, and I'm writing my 5th book, I guess now, on various aspects of global compliance. So it's not just US type of compliance, although that's what we're going to talk about today. So let us get started out. Oh, that's me. I also have a degree in estate tax. I've been a member of the bar since 1978. I've been a member of several other bars, and I basically most of my practice was involved with various types of business laws. And I have a bunch of certifications. The most recent one was the ISO 27000 2022. So if you are certified, make sure that you update your certifications. Exceptionally important to basically do that. I also write wills. So this is the what we're going to do today is we're going to go over various types of cybersecurity laws. We're going to talk about the history of privacy laws. We're also going to talk about the GDPR and why the GDPR is important, and the contrast between the US and most of other privacy laws and why that is different throughout the world. And then we'll also go through various states and their view of privacy laws. Now, right now, there are 5 states that have privacy laws, but last year, we're getting into the silly season right now, and we'll talk about that a little bit, and we'll talk about very special rules and areas that you have to do. And the most important thing we're going to talk about is what you need to get right. Is, yes, it's always good to dot all the I's and cross all the T's. But the reality is, at least depending on how the law is structured, you don't always have to do that in order to protect your organization to do what is necessary. It's what I call legal risk. It depends on the probability of you having an issue with, or the probability of you actually having a problem in terms of a liability or a loss. There's a big difference between getting everything right in a regulation and avoiding a risk. So that's something you really want to look into. And in terms of what we're normally trained in is, and what ISO cybersecurity is looked at, is basically looking at the risk. Anyway, okay, so this is the various types of cybersecurity and privacy laws. All right. There are 2 types of cybersecurity laws. There are basically cybersecurity laws. Actually, no, there's 3 types. There's cybersecurity laws, incident response laws, privacy laws, and of course, and the hybrid laws. The hybrid laws are, we'll go with the first, the cybersecurity laws. Cybersecurity laws are specifically cybersecurity. They have nothing to do with privacy, and that exists in many, many states. For the first example, it's the New York Shield Law. That probably covers the most people. That comes in 3 different flavors. There's the NYDFS, New York Department of Financial Services, and then the Shield. That's for companies above $3 million in revenue that do business in the state of New York. And they have to comply with what they call with 15 controls, basically. If you're below 3 million, you just have to have reasonable cybersecurity, whatever that is. In Massachusetts, what they did is, this is a very, very old cybersecurity law. And that what they did is they said, okay, you have to have these controls, and we're going to tell you what controls you need. HIPAA is like that in 48 CFR 164.300 is their cybersecurity rules, and they say thou shalt have these cybersecurities. And then the more recent type of law is they say it's a risk-based approach, and there are about 25 states in the United States that have these laws, and all they say is thou shalt have cybersecurity appropriate to the type of information you hold. And that's a better way to do it. For example, I believe that one of the phone companies just had a big hack, and they lost 39 million records. But the records were basically email addresses, names, and phone numbers. Now, when you think about that, when I was young, back in the dark ages, we had big fat books called phone books, and we wanted people to get that information. That information is not all that important, and that's not exactly the type of information you want to protect. The best quote I've ever seen for cybersecurity is to find out what is your most sensitive information, and we'll get into that, or most expensive information, and then come up with methods to protect that. So when you're putting together your cybersecurity framework, that's what you have to do, is figure out what is the most delicate information in your systems and figure out how to protect that. Protecting everything may not be necessary, and it may not be anything you can afford. All right. That is for now. In contrast to your cybersecurity laws, they're instant response laws. Now, all 50 states in the United States have these. The GDPR, I believe it's Article 33 and Article 34, all of which just say, you got to respond within 72 hours to the regulator, and whether you respond to everybody else is up to you, is a question. Now, in the United States, you've got the same issue. The problem is every state has one, but unfortunately, they're all different. Some say you have to respond immediately. Others say, when you get around to it. Usually, the people you respond to is the local authority, which is almost always the Attorney General, who probably couldn't care less. In other cases, you respond directly to the people whose records have been breached, and usually that's a number. The problem with instant response is in the United States, it gets into a whole other area having to do with liability. Because in certain cases, if you lose somebody's data, you could be liable for that. I mean, let's say, for example, you entrust me with a library book, and I lose it through my own negligence. Well, I'm liable to you for that library book. And the same could be true for information. Now, fortunately or unfortunately, there is a Supreme Court case called Spokeo, and that has basically said, unless there's very specific loss, then you can't bring an action. And that will depend on a lot of things. There's also a lot of issues around the attorney-client privilege. So how you respond, and it is required in all 50 states, but how you respond and to who is a big deal. The most important thing you can do in regard to instant response laws is to create a plan, so when you get hacked, you know what to do, and that's exceptionally important. Now, privacy laws. A lot of people assume because it's a privacy law that it's also a cybersecurity law. This is not the case. For example, the most recent California law, which basically has all the rights and privileges of the GDPR, the California Privacy Rights Act, which became the law as of January 1st of this year, is only a privacy law. The cybersecurity law is in someplace else. The CPRA is 1798.100 through 165. The cybersecurity law in California is 1798.81. And there are two different laws, so you have to be aware of them. COPPA is the Children's Online Privacy Protection Act. And frankly, that's a mess. So there are several issues in Congress. There's several amendments to COPPA that are basically concerned with this issue, which have to do, none of which have anything to do with cybersecurity. There is SEC Rule S and P. The Rule P is actually out of the Gramm-Leach-Bliley and goes across about 5 different laws. So it's very important. And then there are the hybrid laws, which like HIPAA and the GDPR, which contain both cybersecurity and privacy. Mostly it's cybersecurity. HIPAA also contains an instant response. The GDPR was actually created in 1998. HIPAA was created in about the same period of time, and this needs an update. So that's the distinction. This is what the whole point of this slide is, to show you this is not new. The first privacy came about in 1890 with a Harvard Law Review article in the United States that became constitutionally protected in Griswold versus Connecticut, which is 1995. The 1995, which is the data protection, that's a European. So if you think about the GDPR, don't say, oh, this is a new law, it just got created in 2018. No. The GDPR has been around since 1995, and European companies have been dealing with it for that period of time, and it has not caused any of the collapse or issues that a lot of the big tech lobbyists have been, threatening. It hasn't happened. The European countries have dealt with this law for over 20 years, and it really hasn't caused any problems. It's worked quite well. And if you have problems with the GDPR, get used to it, because for a lot of reasons, it is the global standard, whether you like it or not. The actual the GDPR itself got enacted in Europe in 2016 and was put into effect in May 25th, 2018. But the only difference between the Data Protection Directive and the GDPR is that it just was organized a little differently. It's basically the same law. So these laws have been around for over 100 years. And if you don't believe me, find out who Anthony Bolleo is, who just got $110 million in a privacy action. You might better know him as Hulk Hogan. And so these things have teeth. And the other issue is the era of free data, and data is the new oil, is improper. The new model endorsed by Cisco and McKinsey is that you have to develop a partnership which involves privacy with your customers, and you have to start rethinking how you're doing your strategy. It's a different world. This is the GDPR. Now, these things you have to look at closely, because a lot of things are global now, and this is the type of thing. The idea that you can just take somebody's data and use it any way you want is, shall we say, dead. If you want to see a perfect example of that, look at Meta or Facebook stock price. Meta stock price hasn't risen at all since 2016, as opposed to Apple, that has incorporated protection of data into its marketing strategy, which is quadruple its 2016 price. So this is the way forward, and this is part of what you ought to start thinking about. Now, the big thing for Americans is erasure. And one of the things you have to get right is the ability to get rid of any data you collect. So that's a real big one. The other big one, which is global, is notice. You have to really, really work on your notice provisions, and go big and go broad about the notice. Those are really big. Access is also part of everybody's law. So allowing your data subjects or your consumers or anybody who's used your website the right to go in and look at those data is very important. These security is the big one, because no one is going to care unless you have a breach. And if you have a breach, then all the regulators are going to jump on you. So those are the big three: is the notice, the access, and the security. The accuracy, adequate, attention, are all, sometimes profiling, objective, are all going to be part of a lot of the laws. But the big ones are notice, access, and security. Access I put in for erasure. That's the stuff you have to make sure you got to look at. Okay, the big difference between the GDPR and the Americans is, in the United States, you can use anybody's information any way you want to, all right? In Europe, you could only use it if somebody's consents. Now, most of the world is based on consent, and there are a lot of other laws in the United States based on consent. And opt-out is just sort of, I believe it's sort of a halfway. If you're looking at the strict law, it's a contract with a condition subsequent. That's an opt-out. And there are a lot of laws like Colorado, Virginia, Utah, Connecticut, and potentially the federal law that are all opt-out. Opt-out is sort of like, you can come and take, if I'm renting my car, you can come and take my car anytime I want to, unless I object. And you can use the data until somebody files something and says, don't do that anymore. With the GDPR, you can only, it's more like a contract. You have to sign on the dotted line or have a reason for you to use my information. The point is, information and data are no longer like out there as part of the ether, like air that you can breathe. Data has economic value, and you have to look at it as such. Think of data as something that belongs to your consumer, your data subject, and the whole thing will be a lot easier for you. It's not something that just happens to be free. Okay, these are the 5 privacy law states. Remember, all states have incident response. About half have cybersecurity. These are all privacy, and they all allow certain types of things. They protect, what you can gather. They're all opt-out. They all allow you to have people to go in and find out what type of information you're collecting, and you can all, get rid of it. If I go in and I right to my rights, I go in and find out that you have a certain category of information, I can ask you to get rid of it. That's generally true. There's also, the new concept now are dark patterns. If you're hiding stuff on your website, don't do it. I mean, everybody does that, it's 10 clicks away. Like, if it's a lot easier for you to subscribe to your magazine than stop the subscription, that's probably a dark pattern. It's probably something you should watch out for. Also, be sure to watch these things. They just, a French perfume manufacturer, we just got fined $1 million. They could have, stopped it right there, but they just let the 30 days go by. So be careful with these things. Watch it if somebody wants to do something. These are ways to accurate. Right of correction. Make sure you correct your stuff. Make sure you have a notice. What do you collect? How do you collect it? Deletion. Make sure you have the ability to delete stuff. These are all GDPR types of things, but they're very similar to rights given in the United States. It's not like the GDPR is totally irrelevant to what you basically do. Make sure you get your policy right. Make sure you can erase, and make sure you get your cybersecurity. Those are the biggies. Okay, the big thing to worry about is sensitive data. Sensitive data, it's also on, just similar to Article 9. The problem with sensitive data means different things in different states, but most states have a similar type. It's like healthcare, financial, driver's license, Social Security. Remember, I was talking about the data you have to protect and the data you don't care about. The sensitive data, you really have to make sure it's protected. That also flows through the supply chain. So say, for example, you you've stored all your stuff in Amazon's cloud, and in there is sensitive data. You have to make sure that Amazon protects that as well, and make sure there's some sort of gate there. So you've got to make sure there's an authentication process going on when you have sensitive data. You know, encrypt it, do something with it. But this is something, remember, you have to identify your information, have appropriate controls. The information you've got to identify is Article 9. And this is another list of what that sensitive data is. It's biometric. Be very careful about biometric. There's some huge cases about the Illinois Biometric Information Protection Act. Huge. I'm talking billions. So, the train, Burlington Northern and Santa Fe, BNSF, just got, has an award for $248 million for violation of biometric information. Sex life, you're going to nail people. Health, anything is usually BI, you know, is the H, is HIPAA. So be very careful about these things. CPRA, and the sensitive information changes. Geolocation, a hot area. Another area that's coming along are data protection impact assessments. They're becoming a big. Now, if you have to be anything, be a data processor. If you're a data controller, if you decide that how you know, what you do with data, the purposes and the means, you're a data controller and you have all the liability. The definition of a data controller doesn't change much. So you want to do a processor, but understand that a lot of these duties control, but notice there's no arrow between the data processor and the data subject. So there's no what they call privity in the law between these people. Okay, but the three things that I've said, you've got to get right. Get your cybersecurity. I would definitely suggest a framework like NIST 171 or ISO 27001. That's the only way to do it. You cannot have a technological, if you can do nothing else, do a cybersecurity, but make sure you have a framework. You cannot flip a switch and get the technology and make that happen, because 85% of the hacks are people. Get your privacy notice right and don't use a template. Think about it and be very sure that the more everybody looks at it, you know, like the reason there was a $5 billion fine by the FTC against Facebook is because the marketing department didn't look at it. They were saying things that the marketing department never heard of. They gave it to their lawyers. Their lawyers came up with 5,000 words worth of gibberish, and it was pathetic. So get your privacy notice right. Access request, you know, either opt out, finding out what you've got, rectification, getting rid of stuff like that. Do not sell banners under the California law. Make sure people have a chance to see the stuff. In fact, build trust with these things. This is how you build trust. You build a partnership. Now, here's the American Data Protection Act, which I don't believe is going anywhere, but it is there. This is the latest attempt by the federal government to come up with a protection, a federal protection law, which is going nowhere. The last year, there were 29 states that had introduced a privacy law. There were 14 states where it made it past one of the houses, and at the end of the day, only 2 states adopted it. So it would be much better if we had a federal law, but given what's happening in Congress, I don't think so. I mean, it would be nice, but you know, I don't think there's a possibility of a federal law until the next election cycle. So what we're going to do is we're limited to state law, and there will probably be a whole bunch. I think there'll probably be at least another 3. But the big thing they fight about is the enforcement. If the Attorney General is enforcing it, it's not a big deal. If there are rights of private action, then you might, then every plaintiff's lawyer and their brother are going to be in that. Watch out for the BPIA. That's a big area for litigation now. Watch out for sensitive data, big area for litigation. So, okay, these are the various types of products that we produce. So, and these are various methods that you can ask for more information. Okay, thank you very much. If you have any questions, I have all of 5 minutes. So if there aren't any questions, I'd be happy to answer them now. Otherwise, feel free to ask for my email and I can get back to you on the various types of questions that you may have. Okay, are there any questions? And I have no idea how I can figure that one out. Is there a chat button on this one? So anyway, that is the information I've got. This is the various ways that you can get in touch with us, or you can call us or email us or whatever. If you want to get in touch with me, you can use any of these various types of things. So if there are any questions that you have, oh, there are some questions, unfortunately. Okay, what is that? Okay. Oh, can you get the deck and recording? I believe yes. Oh, Trudy, they'll be sending the slides over the email. So yeah, that can be done. Yes, one of my lovely people who can do that. So that is possible to get that. The other, I'm also writing a book, which will be, I'm not sure when it'll be come out, but it'll be go over global compliance. And that will go over all the US laws and the GDPR. The GDPR is the standard, basically, because Article 44 required anybody to use information of an EU citizen, which is the largest trade bloc, to comply with the GDPR. So all the countries around the world said, hell with it. If we're going to be adequate, we'll just adopt the GDPR. So there's a lot of countries like Brazil and Qatar and Kenya that have just adopted the GDPR. And so that is the international standard. If you look at like consent, that is the exception in the United States, unless you're dealing with sensitive information, which you have to have consent. And then, but otherwise, that's the exception. But for the rest of the world, consent's required. So it's better to start thinking about how you're going to develop a data partnership with your clients rather than, just try to take their information and try to not tell people with cookies what you're actually collecting. The idea of Alistair McTaggart talking to an engineer at Google and getting the response, how much data do you guys take more than you want to know? That's no longer good business. Is there any source you can share that you can follow up on cybersecurity laws? Well, the best source is, D.L. Piper with cybersecurity laws, but that's 100. There are 195 countries out there and 135 different cybersecurity laws. So each cybersecurity law is going to be a little different. If you stick to good cybersecurity, notification and access, you have an 80% chance you can lower the legal risk that it's ever going to problem. If you have a breach, all the regulators are going to come out of the woodwork and all the plaintiffs' lawyers are going to come out of the woodwork, and you'll have problems. But if you avoid that, if you develop a partnership, develop trust with your people, with your customers, and say, look, one of our value proposition is that we're providing you with good cybersecurity laws. You're going to be like Apple, and one of our value proposition is we're going to give you good privacy. You have a much better chance of dealing with what people expect of your firm. The idea that you're going to sell a lot of stuff by stealing somebody's, private data is probably not a good idea. If that's your strategy, you might want to rethink it. But getting all the information on cybersecurity is difficult. So it's, the National Commission on State Laws is good, NCLA. Excuse me. That might be a good one. There might be, a couple of the others. Okay, unless there are any other questions, if you've got any other questions, feel free to contact us. Other than that, I will be ending the show at this point in time. Is there anything else? All right, I guess you're all mute. So anyway, thank you very much for your time. And if you have any other information, feel free to contact us. Thank you.